Idaho court closes a permitting loophole for land splits. Developers have long treated minor land divisions as a faster, lighter touch alternative to a full subdivision filing. And Idaho's High Court just ruled that splitting one project into several small applications does not exempt it from the same judicial scrutiny a subdivision would face. The Idaho Supreme Court ruled on July 8th that two adjacent minor land division applications filed by developer Tricor Investment for a Priest Lake property are subject to judicial review under the state's Local Land Use Planning Act, reversing a district court decision that had dismissed a challenge from neighboring landowners. The case, Budig vs. Bonner County Board of Commissioners, centered on a project that split 8 lots across two 4-lot filings, each falling 1 lot short of Idaho's 5-lot statutory threshold for a subdivision. Bonner County's own attorney told commissioners the split was a deliberate attempt to avoid subdivision requirements. Commissioners approved both applications anyway. The district court sided with the county, ruling that neither filing met the technical definition of a subdivision on its own, and that it therefore had no jurisdiction to hear a challenge. The Supreme Court rejected that framing. Two applications filed at the same time by the same applicant for adjoining land under one owner can be treated as a single project when their combined effect matches what a subdivision filing would produce. Filing paperwork in pieces does not change what got built. Most states use a numeric cutoff, often 5 lots, to decide when a land division needs the heavier review a full subdivision requires. Developers navigating tightening permitting timelines have leaned on sequential minor filings to stay under that line and move faster. Idaho's ruling tells courts to look at what an applicant actually built across adjoining filings, rather than accepting each filing's lot count in isolation. Facilities and infrastructure teams evaluating land for a new site now have a sharper due diligence question to add to the list. Check whether a parcel's history includes sequential minor filings from a single owner that, taken together, look like a subdivision that never got the review one would require. A land parcel with that history carries legal exposure. A clean single application purchase would not. That risk sits next to the interconnection and water questions companies are already working through as part of site selection due diligence, where permitting has become as unpredictable a variable as grid capacity itself. Site selection teams in other states with similar lot thresholds should read this ruling as a preview, not an Idaho peculiarity. You've been listening to Sustainability Soundbites by Environment and Energy Leader. For partnership opportunities, please reach out to our team.